law matters. Of course it does. Welcome again. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you decide how to protect yourself, your family, and your business. We continue to provide information and resources that will help you to decide whether or not you can handle some issues yourself, or you'll be better prepared to work with the counsel you do select. Our goal, of course, is to help you save time, money, and achieve the best possible results. And as we tell you that we want to welcome again and thank Attorney David Bazar from Bazar and Associates Law Firm in East Providence,
Thanks,
who continues to weigh in on the various topics that we tackle. And today, contracts, the basics of consumer contracts. On the one side, you might need some help in understanding the legal responsibilities if you are selling to customers, how to be fair to them, what legalese that you need to understand, and if you are a consumer, as most of us are, you need to know how to protect yourself. How many times have you found yourself saying, this isn't fair? Well, maybe in fact it might not be. So today we'll go through the elements of a contract, what elements might not even be enforceable. Some of them are legal, illegal, unconscionable, and variations of them. Some companies, as you know, or kinds of industries are notorious, so we'll see if we can get to a few case studies that are just unbelievable. So David, what are the elements of a contract?
So if you think about it, we are dealing with contracts in our everyday life all the time. And it can be from a big purchase, an automobile or a home, to buying things online and entering into agreements in that realm. So generally speaking, the elements of a contract there's an offer and an acceptance, and once you have an offer and acceptance, you have an agreement, and in order for that agreement to be binding, there has to be mutuality of obligation, meaning both of you have to be required to perform the contract. There has to be consideration, which is that I am giving you something in exchange for something else, a bargain for element of the contract. The contract has to be legal for a legal purpose. It can't be unconscionable, which is an element not of the contract but of defense of a contract. It has to sometimes, not always, be in writing.
Not always be in writing.
Not always. The statute of frauds is very particular, which is the statute going back to Old England in many regards as to what types of contracts have to be in writing and which ones don't. And then the last element that we didn't really speak about yet, but it's capacity. The capacity to enter into a contract. In other words, you have the legal capacity. Are you a minor, or are you under a guardianship or something? And at the time you enter into the contract, did you have the legal capacity to enter into the contract?
Okay, so that's good broad brush strokes.
That was very broad brush.
So a couple of things that have changed over the years since the advent of the internet and all things that are shopping. When you talk about an offer, consumer offering to buy goods, not just a seller offering goods for sale, offer applies to the consumer who's about to buy?
So the seller is offering to sell the goods, and when the consumer comes along and says, yeah, I like that, I want to buy it, that's the acceptance of that offer. There can be, in many situations, offers and counteroffers, and those have different legal ramifications, and you see that a lot on the home market. So I put my house up for sale, and I offer it for sale for $200,000. The buyer comes along, and he doesn't accept my offer. He makes a counter offer. He says, I'll buy your house for $175,000. Now it's back in my court to say, I accept your offer, or I'm going to reject your offer, or I'm going to make a counter offer to your counter offer. And so that's the best way to understand offer, counter offer, acceptance, rejection. And there's a lot of law, case law, on what constitutes a rejection and what happens when you reject an offer, and what constitutes a counter offer, and all of those types of things.
So if someone clicks on add to the basket, add to the cart on a website, he's considering it, he hasn't actually accepted it yet, right? It's just in his basket.
Right.
As if you take something off the shelf, you could still put it back, and until you've gone through and
Right.
scanned the item or maybe deleted it, that's still
Yeah,
not a firm
that's-
acceptance, right?
I'm really considering accepting your offer, and I really might do that, but right now I'm just putting it aside to see. I'm putting it in my basket to see if it's something I really want to complete the contract with or the arrangement.
How about if someone accepts an offer? Is that the same as making the sale, or are there intermediary steps? And where I'm going with this specifically is something called an order acknowledgement. That's not saying I bought it, but there are stages or shades of gray there, David. How do we avoid some pitfalls?
So this depends on the actual facts of the situation, and it's very fact-driven. So again, real estate's usually the best way to explain some of this, but I make an offer to buy your house, you accept my offer. Now, we have the basic outlines of an agreement, but the contract itself, to be complete, has to have other things that are crystal clear. All of the elements of the contract haven't yet been completed until we make sure we agree on what the subject matter of the contract is. So in the terms of the home, it's the property itself, but it's also the purchase price. And my offer may have some conditions to it. It might be subject to an appraisal, or subject to my being able to get a mortgage, or subject to
Termite
a
inspection.
termite inspection, or any inspection. So we may have a contract, but the contract may have conditions that could be used to activate our ability to get out of the contract.
So let's use my offer about saying we need to have I'll accept it, but it needs to be inspected by a termite inspector. Okay, says the seller. Okay, says the buyer. The seller didn't have it done, and now he still wants to make the sale. You think that it's a done deal, but then does it mean that that buyer can say, I'm not going to buy this house because you didn't hold up your end of the bargain? Is that a breach? Is that not even a contract so that you'd have a breach?
So actually, in that particular situation, we're dealing with property, so we have a written agreement. There's an instrument, because real estate's one of those things that has to be in writing. I can give you some of the others later, but that's in writing. And in that writing are the terms of those conditions. So we have an agreement. The only question is, can you as the seller enforce the agreement against me as the buyer, or can I trigger one of those conditions to get out? So what usually happens, if it's well-constructed and well-written contract, is there's a time frame for me to get that inspection. And if I got the inspection within the time frame and I tell you here are the issues and you're not willing to correct those issues, then I can get out. But if I didn't complete it within that time frame and tell you that there were issues, then that's no longer a condition that I can use to get out of the contract.
Good to know. So you started to broach the subject about written. There are some contracts that are still valid even if they're just oral?
Most.
When?
Many.
Go ahead.
So, what contracts have to be in writing? Some of those are a contract that can't be, by its own terms, completed within 1 year. Well, what kind of contract could that be? Well, I'm buying goods or services from you, and the services aren't going to be delivered until next year, more than 12 months after we entered into the contract. That, by its own terms, can't be done within a year. That's a contract that needs to be in writing. Contract for marriage. We joke about marriage being a contract. Well, marriage is a contract between three parties, the two people getting married and the state, actually. That's a subject for another time, family law. But in the meantime, you enter into a contract to get married. That contract has to be in writing. So anything going back to things that people would have thought were subject to fraudulent things happening. Another one would be someone agreeing to pay the debt of another. A guarantee is what it really is in today's commercial terms, but if I was in merry old England and I said, I know Robin Hood owes the sheriff $5,000. I'm going to pay that for him. That has to be in writing, because anybody could say, well, he said he was going to pay that debt for me. Well, how do we prove that? Put it in writing. So those types of contracts all required writing.
So there are so many, as I refer to, notorious kinds of industries. So for example, on the phone, you are planning to have a cable company install cable in your home. And there's a promotional offer, buy now, and you will have that for 2 years. And you say, well, I think, okay, that sounds pretty good, but how about if I have to leave and I have to shut it off for 3 months? Not a problem, they say. Gut reaction might be to put it in writing, but say they don't, because you just had that conversation on the phone, and at that time, you agreed on that price. And in fact, you did have the thing interrupted for 3 months, and then you call them back and they say, oh, no, that's null and void because we're starting all over. You don't have it in writing. What recourse do you possibly have other than the fact that you could put a bad word on Facebook?
Get it in writing. Because again, just think about some of the terms you laid out. It's a contract for 2 years. By its own term, it can't be completed within 1 year. And some of the other terms that are within there, if the contract itself needs to be in writing, some of those terms should be in writing. So get it in writing.
I have to ask you this, David. You're a lawyer and you review contracts, you write contracts, you prepare contracts. When you're given a contract, even if it is for cell phones or cable, you know the 3-point mouse size type.
Right.
Do you read all of them, or do you just go looking for certain triggers that you know are going to be problems? What do you do?
So are you asking me if I'm like the shoe repairer
Yes,
whose shoes need to be fixed?
Exactly.
I give it to my wife and have her review it, of course. There are certain terms that you do have to look for in any contract that are the key elements of it. I cannot tell you that every contract I've ever signed, including renting a car or buying a car or any of those things, I have read every single term on the back side of the paper, which is on that faded ink that you can barely read in the small print. And sometimes those, because of how they're written and where they are, sometimes can be unenforceable, where they're considered clauses or contracts of adhesion, where they're, you sign this or you don't get it, and it's the only way you're going to get it, and there's no arm's length transaction. You don't have equal bargaining power, and you can't say, yeah, I'll sign that, but we're striking this clause, and this clause, because if you sit there in the car dealership's financial guy's office and start crossing off lines in the contract, he's not going to know what to do, and he's probably going to freak out, and the whole deal's not going to happen. So that's why sometimes some of that boilerplate language, as they call it, may be unenforceable. I can't tell you it will be unenforceable, but it may be.
Would you say that a couple of the known triggers are or things that you should check, cancellation policy and certain terms that are reasonable about payment and disputes?
Right.
Would those be pretty typical ones?
Those are things I would check if I was, and that anyone should do. So on that long lease, if you're entering into a lease, you really need to know, well, what's the payment? Yep, that's the payment. How much can I buy it for at the end of the lease? The residual value, what are you using? That's that number. What are the terms of mileage if you go over? What are the terms of wear and tear? To some degree, you'll be able to find that on the contract. The things that, if you've done this before, leased a car or bought something over the internet that you know could be an issue, you need to look for those things.
What about, so gyms apparently are notorious these days. You sign up for $5 down, 5 monthly or whatever it is, and they say that you can terminate it when you sign off on it. Sounds reasonable, sounds doable, but then in reality, when you want to sign off, they won't let you. They would say, for example, well, you just have to go in and say, scan your badge, and then that will allow you to fill out the form to terminate the contract. So you do that, and it doesn't. And then you do it again, and then they go back and say to you, well, you see, you scanned your badge, so you were here. You absolutely, that's bad business, to say the least. But in terms of you wanting to terminate that contract, where does that leave you? Do most people want to contract a lawyer to get rid of a contract that shouldn't have
It can be a very difficult situation. It comes up a lot. And it's one of those things that if I belong to a gym, when I joined, not that I'm joining with the intent of quitting, but that's what people do.
Yes.
I want to know exactly what it is. I want it spelled out in clear language. I might, as they're telling me what it is, write it and then ask whoever I'm dealing with to sign it in their capacity as manager or whatever, so that I don't want it from their language so much because it's usually incomprehensible. I want it, oh, what do I have to do if I want to terminate this? Oh, you have to give us notice. Who do I give the notice to and how do I give it? Well, you just drop a letter off in the manager's office. Drop letter off in manager's office to terminate. That's all you have to do. Okay, good, I wrote that. Could you please sign it and attach it to the contract? See what they say.
News and information that you can use. That's very helpful. That's good to know. So earlier I mentioned too, there are certain kinds of contracts that might not hold up in court. Some of them are illegal, some are unconscionable. What are the differences?
There's illegal, there's unconscionable, there's lack of consideration, there's capacity, and there's capacity to enter into the contract.
Okay, David.
So let's talk
one.
about legality. A contract can only be enforced if it's a legal contract. So here's an interesting tidbit. The very first reported case in Rhode Island Supreme Court's deciding a contract case. Take a guess at what the issue was in the case.
Marijuana.
No.
No?
We're talking the 1800s.
Oh, 1800s.
Yeah,
I'm sorry.
First reported case, Rhode Island Supreme Court.
What was
It's
it?
a contract case, and the issue was legality. Now, you want to take a guess what the contract was about?
No, I don't, after
Okay.
my first guess.
It was about a bet, gambling contract.
Oh, gambling, okay.
Yeah, it was to enforce a bet. And gambling was illegal, and you couldn't bet. But here was what I find the most interesting part of that case. It was a bet about who was going to win a Senate race. Isn't that funny?
That is funny.
Yeah. So in that case, the Rhode Island Supreme Court said, you can't enforce the contract. The guy who won the bet wanted the other fellow to pay. Sorry, the bet is unenforceable. The contract is unenforceable because gambling is illegal, especially gambling on who's going to win a Senate race.
My goodness. So what happens if they're talking about something that's pending as a law? Either recreational marijuana is or isn't legal at a given moment, but you enter into some contract, and at the time it wasn't, but then it is. How does that work when it's
I think you
gray
got to
area?
look at the, yeah, it could be gray area, but I think was the contract for a legal, was it a legal contract at the time, it was entered into?
Okay.
Capacity is different, and so I always like contracts with real estate because they cover so many elements of the rules of contract.
Okay.
So back in law school, there was a case, and the case was about one fellow who wanted to buy another fellow's piece of property, and he had been after him for years to sell him the property, and he'd been making offers and suggesting, you know, that he'd really want to buy it, and he'd tell him, I pay this much, and he'd say, no, I'm not selling. And so one day they're in a bar, and they're talking about, let's just call it black acre, because that's what they always call all pieces of real estate in law school, white acre or black acre. So buyer says to seller, I'd like to buy black acre, and seller says, well, you know, I'm getting to the point where I may want to sell it. So they're going back and forth, and the buyer takes out a napkin and he starts writing down the terms. Black acre, he describes the property. He says, this is what I'm willing to pay for it. I'll close by 2 weeks from tonight or whatever. And they're going back and forth, and they both sign it. So now the seller says, oh, I don't really want to sell it. We don't have a contract. And the buyer says, oh, no, we have a contract. Well, he says, well, it's for sale of property. It's got to be in writing. I've got the napkin signed by both of us. We wrote out all the terms. Well, it doesn't have all the terms. Well, yes, it does. It describes the property, it gives the price, and it says when we're going to close. Well, I didn't have the capacity to sign. Well, what do you mean you didn't have the capacity? You're not a minor, you're not under guardianship? No, but I was high as a Georgia pine, because it was in Georgia, actually. I was drunk, I didn't know what I was doing. Well, wait a minute. And so the court looks at that case, but they look at it in the totality. on the capacity claim, the amount that was being paid was actually more than the discussions they had had back and forth over the time. So it was clear that he understood that the value being given and offered for it was reasonable. He knew about the property. He actually made a change in the description of the property. The guy wrote something down that wasn't quite accurate, so
They
the seller-
negotiated.
Yeah, they were negotiating. They were going back and forth, and they both signed it. And the court found that it was an enforceable contract. And though sometimes not being of full capacity because of alcohol or whatever might be a defense, in this particular case, they found that they had too many terms and had gone back too much to have that as a defense. And they understood what the consideration was, they understood what was being sold, and both parties were an arm's length transaction, and the court upheld the contract.
So is this a little aside, but would that seller or that buyer have 3 days just to reconsider whether it was on a cocktail napkin or not? Do you have 3 days to say, I changed my mind, as you do with other things?
That's for certain things by statute, where
Okay.
there's the right to rescind. Oftentimes, it's the right to rescind when you're refinancing a home. And the courts don't, on their own, create those rights. They're statutory. So not in this case.
So if you're a 5-year-old child or 10-year-old child signed a contract with someone who was selling encyclopedias in the days when people did that, you came home, you'd be able to say, oh, no, that's an issue about capacity, it's
Yeah.
underage, never mind, it's 3 days, that would never hold up.
17-year-old.
A 17-year-old.
Right. And so interesting cases with minors is 17-year-old goes into a car dealership and negotiates for the purchase of a car. And he doesn't have legal capacity. So what happens? Well, what happens actually is very interesting in that case. The car dealership doesn't have the right to cancel that contract. Only the minor does. So that's called a voidable contract. The contract isn't void ab initio or on its own at the beginning. It's voidable by the minor who had the ability to say, I didn't have the capacity to enter into that contract. I was only 17 and a half. So the minor can tell the dealership, no, that was a great deal and we're enforcing that contract. Or the minor can cancel it, the dealer can't.
How about the fact that the young man misrepresented that he had the capacity to sign for that when in fact he didn't, he was underage?
Or did he misrepresent it? I didn't put that in my fact pattern.
Okay, but did he? Okay, but suppose you were arguing on the other side. Could you say
what
that
happens
that person
in most
misrepresented?
reputable dealerships is you have to produce a driver's license. Isn't that part of what they ask for?
Sure.
So if he had a driver's license and it was misrepresenting a material fact, then perhaps the dealership would have a defense of misrepresentation, but it's questionable.
So in fact, what does constitute misrepresentation? If that person who was trying to sell didn't have the right parameters or boundaries or something, would that be misrepresentation, or just that he was not quite clear because he was sitting in a bar?
That's another very interesting area of contracts. Misrepresentation versus mutual mistake of a material fact. And
Okay,
so there's
David.
lots of cases on that. So misrepresentation, that might best be described as the used car salesman who says this car was only driven by the little old lady from Pasadena with 10,000 miles, and it's a 1972 blue Buick. Okay, so if it had 110,000 miles on it, that's probably a misrepresentation that is material, that the buyer could say, that was not true, that's not what I bargained for, so I'm not buying the car. If it was not really driven by a little old lady, but a little old man, and it still only had 10,000 miles, and it was black and not blue, but you could have seen that, that's probably not a material misrepresentation, and it's probably not a reason you could get out of the contract. So those are material misrepresentations versus just misrepresentations. Mutual mistake of fact. There's an interesting case going way back. one farmer buys another farmer's cow, and the cow was pregnant. Neither one of them knew it. Who gets the calf? And in that particular case, the case law actually goes back and forth in little different ways again, always fact dependent. If one party had reason to know and the other didn't, you might be able to void the contract and get your cow and the calf back. But if neither party knew, mutual mistake of fact, you might not be able to get out of that contract, as the seller, the buyer, might reap the benefit of that. And again, it depends on the facts. That can go back and forth either way.
Here's a true story. Analyze this one if you can in the time that we have left. A car's being sold. This is true. The car's being sold. It's being sold as is. Well, someone starts it and they say, well, it's been on the lot for a while. We'll just charge up the battery. Come back tomorrow. One was given the money for it. Okay, come back, pick it up. The guy goes to start the car and it still doesn't start. Open up the hood. There's no engine in the car, David. Okay. They did say as is. Is that illegal? Is that unconscionable? Does that hold up? Is that misrepresentation? What is that about, David?
Well, the story you told had misrepresentation in it, because I am assuming it was the seller who was trying to start the car and said, oh, the battery must be dead.
Yes.
And if that's the
or
case,
an agent of the owner, but
yeah,
yes.
If that's the case, then there's a misrepresentation, because it's sort of implying that the only thing wrong with the car is the battery's dead, that there's an engine, there's like almost a representation that there's an engine in the car. So that would be a misrepresentation. But on the other hand, if you're buying a car, a used car, you might want to open up the hood and look and say, hey, there's no engine in here.
I can't believe that happened, but it did.
Yeah.
And there's one other element I think we should address, the idea of you signing a contract under duress. What is that, and can you give us an example that might be one of your favorites?
So there's a lot of cases like that. Of course, signing under duress could be, there's leverage, that they're holding something over you, quid pro quo, if you will. No, that's just an aside.
That's another story.
Yeah, but there's some leverage. But there's also the cases usually where there's the older person who doesn't have the ability to make his own decisions, and there's the person who has undue influence, and that's the young woman in the older man's life, or vice versa, because we can go either way with that.
Yes.
And she gets him to go in and sign a will or do something, or sign a contract that he really she was using undue influence to get him to enter into that agreement.
And
because of their relationship.
outright blackmail, certainly, but that would be easier to
That's somewhere
defend.
between, duress would be somewhere between having free will and being criminally blackmailed into doing something.
Thank you. We hope that this has been helpful to you as we address some of the terrible things that can happen with consumer contracts. We appreciate your staying tuned to Law Matters, because, as we say, the law matters to you.